Hi, welcome everybody. It is Thursday at 5 o'clock, and therefore you are at the bar. I'm Inez Stepman from Independent Women's Forum. Thank you for tuning in to our 5th episode of At the Bar, which is a virtual happy hour conversation about the issues at the intersection of law, politics, and culture. You can catch At the Bar every other Thursday at 5 p.m. Happy hour. And we will be streaming on Independent Women's Forum, Facebook, YouTube, and LinkedIn Live. So today I have made myself a little Campari spritz, which is just like a Aperol spritz, except I prefer Campari. Erin, what do you got?
So I'm much more low key with my Diet Dr. Pepper here. I will trade you places, Inez.
So we are joined by Erin Hawley today because Jennifer Braceras is on vacation. So hopefully somewhere I happen to know up I think near the beach, and she's going to be doing some long bike rides and having drinks without having to talk about the intersection of politics, law, and culture. But we are so pleased to have Erin here with us as co-host. So Erin and I will be talking about, we are going to be talking about the Blob, the administrative state. We will be talking with Mark Chenoweth from the New Civil Liberties Alliance about these topics. Now, the administrative state sounds like a poor happy hour conversation. It sounds very technical, and a lot of administrative law is very technical and detailed. But the expansion of the administrative state and how agencies have taken over more and more decision-making power from voters is a huge deal. And I think a lot of what's underlying our current political mess. What do you think, Erin?
Absolutely. And as you said, Inez, maybe not the most interesting topic on first glance, but I think one of the most crucial issues facing our government and our democracy today. If you look back to the Federalist Papers and the separation of powers, you have people no other than James Madison saying that the accumulation of powers from all three branches, I should say. So the accumulation of judicial, legislative, and executive power in the same hands is the very definition of tyranny. And I'm sure we'll hear a lot more from Mark about this, but it seems like the administrative state very much fits that definition today. You've got housed within the same building even judicial, legislative, and executive powers.
Yep. So on that note, I think we're going to bring up in a moment Mark Chenoweth of the New Civil Liberties Alliance, which is an organization of lawyers brought together by Philip Hamburger to provide a more comprehensive pushback exactly on this expanding power and politicization of unelected bureaucrats. Mark has done William Howard Taft one better. He's not just had experience in all three branches of federal government. He actually has experience in all four branches, what now unfortunately must be the four branches of federal government, as well as lots of private experience suing the government. So welcome, Mark. It's so great to have you at the bar.
Oh, it's great to be with you guys. Thanks very much for inviting me to join you.
So to start off with, I'm going to play a little quaint clip, Mark, of how our government is supposed to work from Schoolhouse Rock, right? We have the three branches of federal government. We've got the legislative branch, the executive branch, then the judicial branch, and everything is going swimmingly. So I'm going to play this little clip, and then you tell us why it is no longer applicable.
Ring one executive, two is legislative, that's Congress. See, it's kinda like my circus. Step right up and visit ring number one. The show's just begun, meet the president. I am here to see that the laws get done. The ringmaster of the government. On with the show! Hurry, hurry, hurry to ring number two. See what they do in the Congress, passing laws and juggling bills. Oh, it's quite a thrill in the Congress. Focus your attention on ring number three. The judiciary's in the spotlight. The courts take the laws and they tame the crimes, balancing the wrongs with your rights. No one part can be more powerful than any other is. Each controls the other, you see, and that's what we call checks and balances. says, well, everybody's act is part of the show, and no one's job is more important. The audience is kind of like the country, you know, keeping an eye on their performance.
So, Mark, why is that not how our government operates anymore?
Well, I just think it's interesting and probably indicative of part of the problem today that the video starts with the president, right? That our Constitution doesn't start with the president. Our Constitution, Article 1, is about the legislative branch, right? It talks about Congress and the importance of Congress passing the laws, and the executive branch has very limited powers outside of foreign policy under the Constitution that our founders gave us. The Congress has quite a bit more power and authority. But they have tried to, over time, do away with a lot of that, and not in a sense of doing away with it so that the power doesn't exist anywhere in the government, but rather they've divested that power out of the legislative branch, and they have put it into federal administrative agencies that in many cases report to the government, but in all too many cases, these independent agencies don't even report to the government. And so we have examples, and maybe we'll get to this later, but including my old former agency, the Consumer Product Safety Commission, agencies that are doing things that the president actually opposes. And without that kind of supervision of what the agencies are doing, you don't have democratic control, you don't have democratic accountability for these agencies. And I'd say that's the major problem. The checks and balances that the video tried to talk about go away when you have agencies that are operating relatively unchecked, and in some cases, almost completely unchecked by both Congress and the president. The Consumer Financial Protection Bureau, for example, is one agency that has almost no oversight by Congress, and it has something the Supreme Court did last summer. But we can get more to that specific example. But that's what I would say, Inez, is that the lack of accountability is the main thing that has changed by shifting all these things over to the blob.
So when we're thinking about administrative agencies, and we saw from the schoolhouse video that conventionally we think of government as having three branches. We've got the legislative, we've got the executive or the president, and then we've got the judiciary. So where does the administrative state fit within that? And I think that may depend on whether you're talking about an independent agency or not. But can you just walk us through where administrative agencies fit within the constitutional structure? I mean, possibly both practically today, and then how should they fit? How do they fit under the Constitution?
Sure. So they don't fit under the Constitution, I think is the short answer. My boss, Philip Hamburger, the guy who got the new Civil Liberties Alliance founded, wrote a book in 2014, Is Administrative Law Unlawful? It's a long tome. He calls it his book stop. It's like 700 or 800 pages. But the short answer is yes, it's unlawful. And the reason for that, people have tried to say over time that, well, our founders didn't anticipate this kind of government, but as things have gotten bigger and more complicated and Congress can't do everything, you have to have these agencies. And Philip's move was to say, no, let's go back and look at all of the different pathologies of monarchical rule that existed before the Constitution. And then we can see all of the things that the founders did to try to prevent those kinds of abuses of power from recurring. And yet today's administrative state produces all of those same pathologies that we saw before the Constitution existed. So the idea that the Constitution didn't anticipate the administrative state is false. The Constitution explicitly tried to forbid something like the administrative state from coming about, and yet it snuck in the back door anyway.
Mark, can you tell us a little bit about some of the cases either that you have ongoing or that you have had in the past, so we can really try to demonstrate how this kind of unaccountable power interacts with people's lives and ordinary Americans going about their daily business?
Sure, absolutely. And maybe the best place to start is with the Consumer Financial Protection Bureau that I started to mention a minute ago. Here you have an agency that is funded completely outside of the congressional appropriations process. People may not realize that, but the way that the CFPB is funded is that every quarter it sends a letter to the Federal Reserve and says, we would like this much money. And the Federal Reserve, by law, has to give the money over. Now, there is a cap of like 12% or something like that of the earnings of the Fed, but that cap even goes up over time. But the Fed just has to turn that money over to the CFPB. That's how it's funded. There's no congressional oversight, appropriations. CFPB can tell Congress what it's up to and how it spends its money if it so chooses. But the appropriations committees don't have any control over that. They can't stop CFPB from spending money. And so it's operating largely out of control of the legislative branch. At the same time, it had been operating largely out of control of the president as well, because the director of the CFPB was once appointed and appointed by the president, confirmed by the Senate. But once that person was in charge, they had a 5-year term, and they didn't really report to the president. They were largely independent. And because of that structure, a case went to the Supreme Court last summer called Scalia Law v. CFPB, in which the Supreme Court said, yeah, that's not going to work. You can't have an agency director who's independent like that. We're going to have to sever, at least this was the solution the court came up with, we're going to sever that independence and say that the head of the CFPB now can be fired by the president. But the problem with that is now all that funding I was just talking about that Congress isn't involved with, that's under the direct control of the president now. So that's definitely unconstitutional under our system, to have the president in charge of a funding stream, 12% or more of the Federal Reserve earnings every year, just for the president to direct how to spend against ostensibly to protect folks from fraud and abuse by folks in different kinds of consumer financial sectors, right? So to get back to your question, Egg, how does this affect people? Well, first of all, the agency has tried to get into areas that Congress didn't want it to get into, like auto loans, for example. It's also tried to get into areas like our client, Crystal Maroney, is and I could tell you a little bit more about the lawsuit that we have against the CFPB, but her situation is that she's a small independent businesswoman. She has a law firm where she's the lawyer, and then she has several people who work for her, and they provide advice and counsel to folks in the debt collection industry. She is not a debt collector herself, but she tries to help with compliance and other things with folks who are in that industry. The CFPB doesn't like that industry very much, and so they wanted to collect a bunch of information on her clients, and they made a demand for her to turn over a bunch of records that were attorney-client privilege materials. And she said, I'm not going to do that. And again, the CFPB does not regulate the practice of law. That's up to the state bar. It's not up to the CFPB. But they blow right through that because they don't have the checks that ought to be in place to prevent them from doing that. And so here you have a business person who is trying to provide attorney-client privileged counsel and information to people in a admittedly disfavored industry in certain quarters, certainly at the CFPB. And she is being overwhelmed with outrageous demands. I mean, it would take her more than 100% of the hours that she has in the day to comply with what the CFPB is trying to get her to do. So she has the choice of either going out of business or not complying. Those are really the only two options that the agency is giving her. And maybe that's deliberate. Maybe they just want her to go out of business. They're not really interested in giving her a fair shake. But that's the sort of problem that exists when you have these agencies run amok. And the particular claim that she's making in her lawsuit against the CFPB is that they are unlawfully, unconstitutionally funded, and that Congress has divested itself of the power of the purse in this situation, and that violates Article 1, Section 1 of the Constitution, as well as the Appropriations Clause of the Constitution, for CFPB to operate the way that it does. But that's one example. We have 30. You name the agency, I'll give you another case. We've got tons of lawsuits going on against the government.
So one of my favorite cases, I think it predates NCLA a little bit, but it's a case called Sackett versus the Environmental Protection Agency. And this case is truly something, you would think it was something that was made up, but it's not. This couple, I think, had retired and had their home on a lake. It was several homes back from the lake. So they started to build their house. Then some engineers showed up from the Environmental Protection Agency, or I think the Corps of Engineers, and said, hey, wait a minute, you can't build here. This is a wetland. And they looked around. It's not wet. It doesn't appear to be a wetland. They're in a suburban development. But yet the agency slaps them with a consent decree, which requires them to either restore their lot, their home lot, to its prior condition, or pay something like $75,000 a day. And the really crazy thing about this is if you look at the statute, which is passed by Congress, it says that the agencies shall have jurisdiction over, quote, waters of the United States. Well, as Mark well knows, through a series of administrative actions, that waters of the United States has now been interpreted by this agency to include a suburban development that doesn't have any signs of either certainly a lake or waters of the U.S. Or even a wetland. This case came out the right way. An organization litigated it up to the Supreme Court, but what's particularly sort of crazy or horrifying about this case is the position that the EPA took. They said, look, you have to comply with this order and repair this land at costs of hundreds of thousands of dollars or pay $75,000 a day, but you don't get to challenge it. You don't get to take this to the court at all. And Mark, can you just tell us a little bit about what's wrong with a scenario like that? And do you see other places where agencies are so clearly abusing their discretion?
We do see other places like this where exactly the situation you describe, where agencies are essentially trying to extract the penalty up front before you ever get a chance to test your legal rights. Or if you want to assert your legal rights, then the agency claims, well, that's fine, but you're going to have to pay $39,000 a day or $75,000 a day or whatever it is, these massive fines that no one can actually afford to pay. So it's just another way of saying it would be like, if you want to take it to the criminal context, it would be like setting a bail amount that no one could meet, right? Sure, we'll let you out of jail pending trial, but you have to pay us $10 million. Very, very few people could ever hope to do that, right? So you would just be sitting in jail until trial, even if you had good arguments as to why you were innocent and hadn't had a chance to defend yourself yet. Now, this is a similar sort of situation, but it's in the administrative context, or you're talking about, Erin, the environmental context. We see this as well. The environmental context is a very big area where we see this happen a lot. The EPA likes to throw its weight around, and I think it'd be great if Congress could do something about taking these daily fines down, because it's one of the things the agency definitely uses to abuse its power. But we see that same sort of thing happen in some of the banking regulation areas. We see it at the state level as well. We filed an amicus brief earlier this year against the California Coastal Commission, which decided to fine a couple in Malibu, I believe it was over $4 million, supposedly for putting a fence. And when I say a fence, you might be imagining something that's like 100 yards long, but this was in Malibu, and there's a cliff, and there's a dangerous area where, yes, there's a public beach and people can access it, but if you try to go through this one area, there's a cliff that you're going to encounter, and it's dangerous. And so I don't think these homeowners even erected the fence. It was there when they bought the property, but the agency came in and sued them over this and said, you're blocking public access to the beach, and we're going to fine you $4 million. So of course they take down the fence. This didn't stop them from having to pay the $4 million, but they take down the fence, and a couple of days later, the government comes in and puts up a fence because it's dangerous and they don't want people accessing it. It's just right. It just boggles the mind. And so exactly why do they need to pay $4 million? Because they put up a fence instead of the government. I mean, it's that kind of thing that's so maddening about the way that the government.
Yeah, it really is, as Hamburger wrote in his book that you referenced. It really is kind of like a kingly prerogative, right? It seems like it's totally disconnected from the idea of the government working for the people. But you mentioned that Congress could change this. They could, for example, pass a statute that says that the agencies cannot fine people, trap people with fines like this. I have a little meme here for what Congress is actually doing. You get legislative power, and you get legislative power, and in any case, it's pretty clear that Congress is writing a lot of statutes where they're just pushing off any kind of political accountability for things that might be specific or unpopular to the administrative agencies. I mean, what do we do about how much Congress has atrophied in terms of writing these statutes?
So Congress could solve the problem, right, to a certain extent, at least for things going forward in the future. But part of the problem with the delegation of power is that Congress doesn't have a good way to get it back, right? Once it's done, the reason I don't use the term delegation, or at least I try to avoid it unless it's necessary for the person I'm talking to understand my point, is because when you say that I'm delegating power, the implication is that I can get it back, right? If I'm the director and I'm delegating something to the deputy director to get done, well, the understanding that both of us and everyone else has is that at any point in time, I can tell the deputy director, you know what, never mind, I'm going to do that myself. That's delegation. That's not what happens in Congress. When Congress passes a law and creates a new agency or gives power over to an agency and says, you go write regulations to solve this problem. Well, if Congress doesn't like the regulations that the agency writes, they have to pass a new law in order to overturn those regulations. Well, who has to agree to that new law? The president. So if the regulations were written in a way that the president likes and Congress doesn't, Congress is out of luck. They'd have to get a 2/3 vote of both houses to overturn a presidential veto, and that's almost impossible to do. So they're not really delegating legislative power, they're divesting the power. They're giving up power that they cannot and will not get back when they turn over the ability to these administrative agencies to legislate in the various areas that we're talking about.
And what about the argument, Mark, that we hear a lot that this is really just something Congress has to do, that the government, for better or worse, is large now. I'd say worse. But these administrative agencies have a lot of technical authority, technical expertise. They know about the environment, for example. They know about things that is just not possible for legislators to know about.
Well, I think there's multiple responses to that. I mean, I think that, if I worked for the Cato Institute, my response would probably have something to do about the size of government and so forth. But one of the things that NCLA has tried to stress is that this isn't really a size of government issue necessarily. Now, would a smaller government violate fewer civil liberties? Sure. And so there could be a reason to prune it back for that sort of reason. But all we're trying to say is, look, if these administrative agencies are going to exist, and obviously they're going to for the time being, there's no reason why they can't respect people's civil liberties. There's no reason why we can't have constitutional guardrails on the agencies and say, look, if you're going to do these things, fine. But for example, if you're going to have an adjudication in an agency, you can't take away someone's jury trial rights. Right now, and you guys may or may not realize this, but there's 10 times as many cases that are brought in front of administrative law judges every year as are brought in front of Article III federal judges. 10 times as many. So, or I said that slightly wrong. So 10 times as many people go in front of an ALJ as go in front of a federal district court judge. Now, the problem with that is if you are in one of these proceedings, and most of our clients most of our cases involve ALJ proceedings of one sort or another, you don't have the federal rules of evidence protecting you. You don't have the federal rules of civil procedure protecting you. You don't have a jury. And folks say, well, but there's a backstop of a federal judge review. Not really, because by the time you get a federal judge to review it, first of all, you don't go to federal district court. You go straight to the Federal Court of Appeals in most cases. You don't ever get a jury to review the facts. You're stuck with the factual findings made by the ALJ. You're stuck with the administrative record created by the agency and approved by the district court judge. You don't have an opportunity to get any additional facts in front of the fact finder. In fact, the Court of Appeals isn't a fact finder at that point. They're supposed to just defer to the factual findings of the agency. So the idea that there's any sort of Article III backstop, just not true. At least not in a way that provides the bulwark for our civil liberties that jury trials were meant to provide. And then a lot of the other rest of the Bill of Rights goes away as well. You don't have the right to counsel necessarily. You don't have the right to not testify against yourself. You're not free from searches and seizures. You don't have the right to the provision of defense witnesses. I mean, there's all sorts of things. I mean, you can just sort of look at the entire Bill of Rights, particularly the 4th, 5th, 6th, 7th, 8th Amendments, and the things that really go to criminal penalties and protecting people. And those things are almost entirely absent from administrative proceedings, which is why the administrative agencies, when they have a choice, prefer to go in front of their in-house judges instead of in front of Article 3 courts, because they don't have to give you your rights. Rights have become options when federal administrative agencies are involved, rather than something that the people can count on and rely on to protect their civil liberties.
So there's a whole question here that's missing. You mentioned the courts, the federal courts, as a backstop, Article 3 courts as a backstop. I mean, so the courts arguably have decided that they're going to go ahead and defer to agencies in matters of interpretation. And we have a little viral video. This was actually going very popular when I was in law school and when I was studying for my admin law exams. So we have a little video about the so-called chevron two-step. And then I'm going to ask you what federal courts, when we come back, what federal courts could actually do in terms of stopping this kind of what I would term lawless behavior by agencies.
This is the final examination for administrative law at New York University School of Law. Please have your IDs out on the table. The exam is 4 hours long and open book. You may begin.
Yo, let's do the chevron two-step.
Chevron two-step. Chevron two-step. Chevron two-step. I'ma do the chevron, you do the chevron, we do the chevron, two-step. I'ma do the chevron, you do the chevron, we do the chevron, two-step. I'ma do the chevron, you do the chevron, we do the chevron, two-step. I'ma do the chevron, you do the chevron, we do the chevron, two-step. I'ma do the chevron, you do the step. Everyone around looking at me making bets. I review the policy according to my preference. I give deference. Step 1, is there ambiguity? Step 2, looking for reasonability. If it passes the test, then it's as good as gone. We defer to the agency. It's called the chevron. I'ma do the chevron, you do the chevron, we do the chevron, two-step. I'ma do the chevron, you do the chevron, we do the chevron, two-step. I'ma do the chevron, you do the chevron, we do the chevron, two-step. I'ma do the chevron, you do the chevron, we do the chevron. So me comes along, tries to be a hero. Gotta make it difficult at a step 0. Now we gotta look up for congressional intent. Did Congress authorize the agency to implement? If we think that it did, then we move along. Did the agency do it? Did it hide the ball? Trying to sneak policy with a false alarm. If it fails step 0, don't lose your teeth. Get more in as good as chevron, but it beats free. Wait, constitutional avoidance, more like congressional annoyance. But Congress can't be delegating all the big questions. They should make policy, that's why we have elections. So long as the agency's resolution doesn't get too close to the Constitution, put your hands on your head and crack a yawn. We just kicking back, doing the chevron.
This is just a reminder of the cycle of cringe, right? Those of you who think
I love
that's
it. I haven't
really
seen
lame,
that before.
good luck. In 10 years, you're going to be cringe and lame too.
They have much better moves than I ever did.
In any case, Mark, they're talking about the chevron doctrine, obviously,
Sure.
and could you lay out for us what that doctrine is, and then also why NCLA thinks that it needs to be pared back or narrowed or maybe even eliminated altogether?
Sure. I actually think the video did a fantastic job of laying out what chevron is. So when if an agency has jurisdiction over a particular question, if Congress has assigned that question to the agency, then the first question is the statute ambiguous about what Congress wanted? And if there is ambiguity, that's step 1, to determine whether there's ambiguity. And there are a lot of traditional statutory interpretation tools that you use at that step to discern whether the statutory language is clear or whether there's ambiguity. But once you've determined there's ambiguity, then the second step of chevron is whether or not the agency's interpretation is a reasonable one or not. And if it is, then judges are instructed by the Supreme Court's chevron decision, which, by the way, was a decision handed down in 1984 with only 6 justices sitting. There were 3 justices recused from the case. They didn't think that they were doing a watershed moment in administrative law at the time that they handed down the decision. And yet it's developed this talismanic significance across all of administrative law. It is the most heavily cited case Even though it's only been around since 1984, it's cited more than Marbury v. Madison. It's cited more than Roe v. Wade. It is the single most cited law case in American history. And what it tells the lower federal courts to do is to defer to agencies when they have reasonable interpretations of laws that are under their jurisdiction. And you said, so what's the problem with that? Well, we would need about 5 more shows to go into all the problems with it. But let me give you a couple of the smaller, or not smaller, these are huge problems, but a couple of specific concerns with Chevron. First, imagine that you are in a lawsuit against a federal administrative agency. Either it's one of those enforcement actions I was talking about before where they're coming after you, or maybe you're suing the agency over something that you think the agency has done wrong or has misinterpreted. Well, presumably you think you're going to get a fair trial, and the due process of law dictates that you should get a fair trial. Well, how fair is it if when it comes to the very issue that you're suing over, the crux of the case involves whether the agency is interpreting the statute correctly or not, and your judge, your supposedly independent adjudicator, is instructed to defer to your opponent's interpretation of the law, right? That is not due process. That is not a fair trial. Because what Chevron dictates is the agency wins even if its position, as long as its position is reasonable. So even if the judge thinks that your position, your interpretation of the law is better and more reasonable than the agency's interpretation, you still lose. So that's a huge problem from a fairness, from a due process standpoint. Now, the second problem that we see with all of these doctrines, and by the way, one of the problems with deference is it's not just Chevron, it's a multi-headed hydra. There's at least a dozen different kinds of judicial deference that NCLA is fighting against right now. But the other problem is that it does away with judicial independence. And I hinted at that before in terms of the judge having to defer to the agency. But if you look at the Constitution, all of the various things that have been put in to assure the independence of the judiciary, lifetime tenure, their salaries can't be changed, no religious test, they can't serve in Congress at the same time as they're a judge, they can't serve in the Electoral College at the same time as they're a judge. There's all of these things that are put in place just to preserve and protect the independence of the judiciary. Dozens, well, I haven't counted, but at least a dozen provisions of the Constitution go to try to protect the independence of the judiciary. And with one fell swoop, Chevron comes in and says, independence is overrated. Judges just defer to the administrative agencies. Well, I think that violates the judicial oath. I think it violates Article 3. And we need to get rid of these judicial deference doctrines so that we can get back to having an independent judiciary that our founders gave us. And if I don't know how long you want to spend on this particular topic, but there's one case pending right now at the U.S. Supreme Court that could be helpful in this. We have filed a cert petition on behalf of a gentleman who's sitting in federal prison named Marcus Broadway. And the particular issue in his case has to do with Stinson deference. This is one of these dozen kinds of judicial deference. Stinson deference is deference to the commentary of the U.S. sentencing guidelines. So Congress put out these sentencing guidelines, and there's a U.S. Sentencing Guidelines Commission that can change them over time. The changes, the amendments that it makes go in front of Congress. It can vote them up or down. That's all fine for the most part. But then the agency, or rather the commission, has gotten into the habit, instead of amending things, because that's kind of tough, and you have to get Congress's assent and all that kind of thing. They've just decided to start sneaking things into the commentary to the guidelines. And if it's in the commentary, then the Stinson deference says you have to defer to it. Except the problem is, then you have people's sentences, like Mr. Broadway is deemed an armed or deemed a career criminal as a result of something that's in the commentary that's not in a federal statute. Congress never voted on it. And again, we think that's a real due process problem. And hopefully this is one area of deference that the court will be willing to clean up. We should know by June 30th whether it's going to take either this case or there's a couple other Stinson deference cases pending at the court right now.
Oop, Erin, you're still muted.
Thank you. Thanks, Inez. We know we've got several new members of the court who have had, I think, some different perspectives on Chevron and on the powers of agencies. So what do you think are your chances if the Supreme Court does grant cert in Broadway or some of these other cases that challenge the Chevron doctrine more broadly? Do you think that it's possible the court might make some inroads?
I think it's possible the court will make some inroads. I think that the different justices do have different perspectives on this. I mean, I think Justice Gorsuch was probably the most, when he was on the 10th Circuit Court of Appeal, was the most upfront about his opposition to judicial deference doctrines, and was very eloquent, in fact, with his opposition and explanation for what's wrong with Chevron and the other doctrines, Brand X.
To jump in with this little tidbit that Mark is probably too humble to say about his own organization. I do remember that during Justice Gorsuch's confirmation hearings, the word Hamburgerian was thrown around a lot to describe his judicial philosophy.
That's funny. The other thing that happened when Amy Coney Barrett was was going through the confirmation process, we got a couple of emails and things sent to us saying, "Hey, when she teaches this area of law, hamburger's on her syllabus." And so there was this little mini tempest in a teapot over the fact that she had hamburger stuff on her syllabus teaching about this area of law. So yeah, I do think that Gorsuch, Barrett, certainly Justice Kavanaugh. What Kavanaugh has said, though, particularly on the D.C. Circuit, is that he has sort of a major questions doctrine approach, which is to say that, well, if it's a major question, then we don't lightly assume that Congress assigned this to the agency. We would be less likely to see that as an area where we have to defer. And Chief Justice Roberts has given some articulation to that idea as well over time. But it's not that there's anything wrong with that doctrine, but if that's all you're going to do to rein Chevron in, that doesn't rein it in very much or very far. So I hope that they'll look at something more fundamental, like the violations of due process that occur as a result of judicial deference. Stinson, the way that Stinson deference came about, by the way, it was a case where the commentary to the sentencing guidelines was reducing someone's sentence. And then that made it up to the court, and the court said, "Oh yeah, that's fine." Well, so they never actually grappled with this problem of someone's sentence increasing as a result of something that is in the commentary. And I think that folks understand, based on the rule of lenity and some other concepts, that you can't have ambiguous things being interpreted against a criminal defendant. And yet that's what Stinson deference does. So again, I think there's different arguments about all the different kinds of deference. But I do think, to answer your question, Erin, I do think that there will be some movement. I hope that it's significant movement and not just marginal movement on these judicial deference doctrine questions.
Well, I wish Justice Scalia were alive for a lot of reasons, but one of them would be to get his input on this case, because as some of our listeners may know, he was behind the Chevron doctrine, had started to rethink that in recent years. But he was also a firm believer in the role that judges have in giving out sentences, sort of under Article 3, and then also in the rule of lenity. So any predictions on what a Justice Scalia would have done in the Stinson case, or in the broader case that raises Stinson deference?
Yeah. So a couple of thoughts on that. One is that we were told by a clerk that Philip Hamburger's book was on Justice Scalia's desk when he passed away. So I don't know how far he had gotten into it. So I don't know I don't know whether he had been persuaded over to this point of view or not. I can say that one of the most atrocious versions of judicial deference is the Brand X doctrine. And it holds that even if there's a prior on-point precedent from a federal court of appeals interpreting the statute in a particular way, if the agency has subsequently interpreted it through a rule in a different way, that court still has to defer to the agency rather than its own prior precedent. That's what Brand X says, which is, talk about a real violation of the idea that the judiciary is supposed to say what the law is. And the author of that Brand X decision was Clarence Thomas, which I think is surprising. But I'm happy to say that when NCLA filed a cert petition last year at the Supreme Court in a case called Baldwin v. IRS, that even though the court denied cert, Justice Thomas wrote a very eloquent dissent from the denial of cert, repudiating the Brand X doctrine, saying that we had come to the brink of administrative absolutism as a result of some of these judicial deference doctrines, and that he was prepared to walk back from the brink, and he hoped that some of his fellow justices would join him. So if Justice Thomas was willing to see the error of his ways on this issue and show that kind of humility, and as I say, it's a very eloquent dissent from the denial of cert. I commend it to everyone. I think I believe Justice Scalia might have shown the same sort of, let's call it growth over time, because that's what the left likes to call it when people change their minds on the court in a liberal direction.
Well, I was going to say it's what happens with the administrative state. But I want to touch on something that maybe NCLA doesn't often get into, and I understand you guys take cases politically from all corners of the spectrum. You don't care if these cases are advancing conservative or liberal policies. You are just concerned about the restraint of the administrative state. But in the last administration, I think we saw a move that was unprecedented even within. So conservatives have been talking about the expansion of the administrative state for a long time, have been, arguing that Wilsonian ideas about this neutral, supposedly sort of neutral scientific form of government that's divorced from any real democratic accountability with the people is a pipe dream. And that it is inherently political, and that you can't take politics out of politics. So it's best to give the voters oversight when policy decisions are being made. But it seems to me that in the last administration, we saw the next iteration of the administrative state, which is the fact that we know from FEC data that the folks who work for the federal government are overwhelmingly Democrats and left-leaning. So, for example, in the 2016 election, 95% of the political donations that were recorded by the FEC from federal employees went to Hillary Clinton. So there is a very lopsided ratio there. And we saw the administrative state essentially fight back against the president, who was kind of unable to control. I mean, the entire quote unquote constitutional theory of the administrative state is that it's going to be controlled primarily by the president and occasionally oversight from Congress. But here we saw very clearly, we saw a lot of politically motivated leaking. We saw active slow walking of any of the policy priorities of the administration. Of course, we saw a lot of this play out in the course of impeachment. We basically saw people who are unelected bureaucrats try to stop the policies of the elected president within the administrative branch. I mean, what do you think about it? What do you think about that development? The fact that the administrative state is now not just throwing around its policy weight, which is what I think conservatives and people who are worried about its power have been talking about for a long time, but it's now like actively interfering in politics, not just, policy or how the rules are written, but actively interfering in politics.
Right. And so that takes that destruction of your voting rights to a whole new level, right? It's bad enough that these agencies are doing things without accountability and in a way that you've not had an opportunity to vote on the way that you can vote on what Congress is doing, or at least who you're sending there to do the voting. But if they're actively working against a democratically elected president, then that's worse. And you definitely saw that. I live in a neighborhood in Arlington, Virginia, and I won't out my neighbor here, but at the block party, I had one neighbor who was actively bragging about all the work that she was doing to slow down and interfere with the Trump administration. I mean, this is the mentality that otherwise nice and decent neighbor type people have when they are in these federal bureaucracies, and particularly in the administrative agencies. And so it's very worrisome. I don't know what we do about it other than, I think there were a few different dynamics that were taking place, right? There was the lie that was told about Russian collusion that I think some people were sort of justifying their behavior based on this false narrative that was being peddled. And hopefully we won't see a repeat of that sort of thing again. We also had a president in President Trump who wasn't a previous office holder and didn't have a bunch of folks to kind of bring in power with him. Usually if it's a governor taking over the presidency, they have a lot of folks in their network, like Governor Bush did, that they can kind of bring with them and put trusted lieutenants in different places around the federal government. Trump didn't have enough trusted lieutenants that he could put in places around the federal government. And then we saw the slow rolling on the part of the Senate trying to prevent all of these different political appointees from being confirmed, so that even years into the Trump administration, you still had a number of unfilled positions. And that, of course, empowered the the unelected bureaucracy below those levels to have even more power than they otherwise would. So there's different places there that we can attack that problem. But it might be time to think about civil service reform as well. It's not something NCLA works on, but
that's my Mark knows that's my
I do.
I was at a different organization before IWF, and it had nothing to do with what I was working on there, and I still managed to put out a white paper on it, just like force them to do it. Same thing with IWF, but this is my little bugaboo. I think that if unelected bureaucrats are going to be making policy and interfering with politics, then they ought to be directly responsible to their bosses who are elected, just like every other at-will employee in the United States. But Erin, why don't you ask the last question here?
So this is sort of a pet project of my own, but I would love to hear a little bit about the non-delegation doctrine. And as Inez mentioned, there's sort of two ways that you can think about justifying the administrative state. One is that the administrative state is constitutional because it is, I'm getting some feedback here, but the administrative state is constitutional because it reports to the executive. The other sort of theory is that it's okay because Congress has sort of given or authorized agencies to make these rules. But then we get the non-delegation doctrine, and I'd love to hear a little bit about, Mark, whether you think it's true that one way we can sort of rationalize the administrative state is because Congress is setting the policy and the agency is simply carrying it out, or should we think about having courts or hoping that courts and pushing cases toward courts so that they will actually require Congress to do that?
Yeah, so I think that it depends on what it is that Congress is delegating. I mean, I think at a minimum, when Congress is delegating core legislative power. So, for example, back to the CFPB case I was talking about earlier, if Congress is going to give up the power of the purse, that's a problem. And the Supreme Court, I mean, lower courts should jump in too, but the Supreme Court should certainly jump in and tell the CFPB, no way, no how, you cannot be funded that way, and strike down the funding mechanism. And if that means the CFPB goes unfunded for 6 months while Congress is trying to figure out a way to fix the funding mechanism, so be it. But I think that we need that kind of discipline to prevent Congress from giving away too much power. If you're talking about areas where, like foreign policy, where and I think that Justice Gorsuch talked about this a little bit in the Gundy case, some of the more traditional executive areas, whether it's foreign policy or immigration or some other places, maybe it's okay for Congress to not have quite as tight a rein over those areas. But all too often what we see is Congress just sort of ceding the floor to an agency to write whatever rules and regulations it wants to. And if it's setting policy like that, then really it ought to be Congress and not the agency that is doing that activity. One of the things that Philip Hamburger has talked about, and I think this would be a terrific way to go, is to have any action that an agency takes sunset unless and until Congress approves it. And I understand that it might take a constitutional amendment to do that, so maybe this is unrealistic. But if we're going to have these administrative agencies in place and we want democratic accountability for the actions that they undertake, then maybe we need to flip it a little bit and we need to say, okay, that's fine. You can propose something or you can put a rule or regulation out there, but it's only going to be in effect for whatever it is, a year or something. And if Congress doesn't approve it, it goes away. And I think that would be one way of trying to restore some democratic accountability. The other way is through a reinvigorated non-delegation doctrine. If the courts would clamp down on that, I should say, a little bit more, then I think that would be wonderful as well. But I think that they could do that piecemeal over time. I don't think you're going to get one giant non-delegation decision from the court saying, okay, now federal courts go to town, start cracking down on these agencies. But I do think that they can identify things over time, whether it's the power of the purse or it's certain kinds of policies that Congress has allowed to sort of leak out into the agencies. If they could pull back on some of those over time, then I think the agencies would adjust and you'd see less. I think that there would be a sort of training effect. That's not the best term. Maybe you guys have a better one, but there'd be a sort of French Foreign Legion effect. Sometimes people call it, right? If the Supreme Court would take out one of these agencies or the abuses of power at one of these agencies, the other ones might say, oh, wait a minute, okay, hot stove, maybe we need to step back and not step over the line as much as we're doing, and start to respect those constitutional guardrails that we were talking about earlier.
A little deterrence through strength there. Well, that's really what it's all about, right? It is about making sure that our government is actually accountable to the American people, and regardless of the decisions, the political decisions the American people make, it's about making sure that they're actually the ones making those decisions. Because oftentimes it seems recently, in recent decades, that although we have all of these fights over voting laws, all of these fights over who's voting, that actually the policy that we're voting on is more and more circumscribed as more and more issues are decided by people who never have to stand for election. So I do thank you for coming on, Mark, and helping us all to understand something that I think, even though it's complicated, is absolutely critical to the continuance of self-government. And thank you to our audience. I have just about finished my drink, which means that At the Bar is coming to a close. You can catch us every 2 weeks at the IWF Facebook page, LinkedIn, or a lot of other places. And thank you for tuning in this week, and hope to see you in 2 weeks.
Thank you.